Sworn do find the defendant, Kathleen Dreamer, not guilty of misconduct of members or employees of Board of Elections in violation of 3599.16F of the Ohio Revised Code as charged in count 3 of the indictment. This form has been signed by all 12 jurors in ink. Count 4, with respect to the defendant, failure of registrars, judges, and clerks to perform duties. Verdict. We, the jury, in this case being duly impaneled and sworn, do find the defendant, Kathleen Dreamer, guilty of failure of registrars, judges, and clerks to perform duties in violation of 3599.17A7 of the Ohio Revised Code as charged in count 4 of the indictment. This verdict form has been signed by all 12 jurors in ink. Count 5. With respect to defendant Kathleen Dreamer, failure of elections official to enforce the law. Verdict. We, the jury, in this case, being duly impaneled and sworn, do find the defendant, Kathleen Dreamer, not guilty of failure of elections official to enforce the law in violation of 3599.32 of the Ohio Revised Code as charged in count 5 of the indictment. This verdict form has been signed by all 12 jurors in ink. Count 6. With respect to defendant Kathleen Dreamer, interference with conduct of elections. Verdict. We, the jury, in this case, being duly impaneled and sworn, do find the defendant, Kathleen Dreamer, not guilty of interference with conduct of elections in violation of 3599.2481 of the Ohio Revised Code as charged in count 6 of the indictment. This verdict form has been signed by all 12 jurors in ink. Count 7. With respect to defendant Kathleen Dreamer, custodian of ballots, papers, or making devices, offense, and penalties. Verdict. We, the jury, in this case, being duly impaneled and sworn, do find the defendant, Kathleen Dreamer, not guilty of custodian of ballots, papers, or making devices, offense, and penalties in violation of 3599.2381 of the Ohio Revised Code as charged in count 7 of the indictment. This verdict form has also been signed by all 12 jurors in ink. With respect to defendant Rosie Greer, count 1, misconduct of members and employees of the Board of Elections. Verdict. We, the jury, in this case, being duly impaneled and sworn, do find the defendant Rosie Greer not guilty of misconduct of members or employees of the Board of Elections. Verdict. We, the jury, in this case, being duly impaneled and sworn, do find the defendant Rosie Greer not guilty of misconduct of members or employees of the Board of Elections in violation of 3599.16A of the Ohio Revised Code as charged in count 2 of the indictment. This verdict form has been signed by all 12 jurors in ink. Count 3. With respect to defendant Rosie Greer, misconduct of members or employees of the Board of Elections. Verdict. We, the jury, in this case, being duly impaneled and sworn, do find the defendant Rosie Greer not guilty of misconduct of members or employees of the Board of Elections in violation of 3599.16F of the Ohio Revised Code as charged in count 3 of the indictment. This verdict form has been signed by all 12 jurors in ink. Count 4. With respect to defendant Rosie Greer, failure of registrars, judges, and clerks to perform duties. Verdict. We, the jury, in this case, being duly impaneled and sworn, do find the defendant Rosie Greer not guilty of failure of registrars, judges, and clerks to perform duties in violation of 3599.17A7 of the Ohio Revised Code as charged in count 4 of the indictment. This verdict form has been properly signed by all 12 jurors in ink. Count 5. With respect to defendant Rosie Greer, failure of elections official to enforce the law. Verdict. We, the jury, in this case, being duly impaneled and sworn, do find the defendant Rosie Greer not guilty of failure of elections officials to enforce the law in violation of 3599.32 of the Ohio Revised Code as charged in count 5 of the indictment. This verdict form has been signed by all 12 jurors in ink. Count 6. respect to defendant Rosie Greer, interference with conduct of elections. Verdict. We, the jury, in this case, being duly impaneled and sworn, do find the defendant Rosie Greer not guilty of interference with conduct of elections in violation of 3599.24A1 of the Ohio Revised Code as charged in count 6 of the indictment. This form has been properly signed by all 12 jurors in ink. Count 7, with respect to defendant Rosie Greer, custodian of ballots, papers, or making devices, offense, and penalties. We, the jury, in this case, being duly impaneled and sworn, do find the defendant Rosie Greer not guilty of custodian of ballots, papers, or making devices, offenses, and penalties in violation of 3599.23A1 of the Ohio Revised Code as charged in count 7 of the indictment. And this verdict form has been signed by all 12 jurors in ink. Anything further from any of the defendants?
Your Honor, on behalf of the defendant, Jackie May, asked the jury with regard to the verdicts on Jackie May.
Any requests from defendant Dreamer?
We also request that, Your Honor, with respect to the counsel for Captain Dreamer.
All right, ladies and gentlemen, I'm going to ask you each individually if these verdicts that I've just read is in fact your own individual verdict as well. With respect to your decisions in the State of Ohio case versus Kathleen Dreamer and State of Ohio versus Jacqueline May. Answer yes or no when I call your number. Juror number 1. Are these your verdicts?
Yes, Your Honor.
Juror number 2.
Yes.
Juror number 3.
Yes.
Juror number 4.
Yay.
Juror number 5.
Yes.
Juror number 6.
Yes.
Juror number 7.
Yes.
Juror number 8.
Yes, Your Honor.
Juror number 9.
Yes.
Juror number 10.
Yes.
Juror number 11.
Yes, Your Honor.
Juror number 12.
Yes, Your Honor.
Anything further? Anything from the State of Ohio?
No, other than we should thank the jury for its service.
All right, ladies and gentlemen, your duties are ended now. My admonitions to you about talking about this case is now ended. All I ask on behalf of your fellow jurors that if you do decide to speak with anybody, that you only speak for yourself and not speak for the jury as a whole. You're excused. The jury service is done. Go back to the jury room. I'm going to come back and talk to you for a couple of minutes before you go, and then you'll be free to go. That's all right, students. All right, please be seated.
That they let out on the same bond that she was on prior to the trial.
Would you like a pre-sentence investigation
Yes,
report?
absolutely.
And on behalf of defendant Dreamer?
We also request a pre-sentence investigation report be completed and that she receive the same bond for that.
And do we have a sentencing date?
February 26th.
All right. Will, any objection from the State of Ohio? All right, I'll accept the recommendations of your attorneys. You're going to go down to the 7th floor now to our probation department. You're going to remain free on the bond that you've already posted. You're going to make an appointment to come back and talk to a probation officer. Be honest with that person. So I have all the information necessary to make a decision about what's the right consequence in this matter. And make sure you don't miss that appointment. If you don't go to that pre-sentence investigation appointment, and I don't get a pre-sentence investigation report, I can't even consider the possibility of probation. So it's important that you don't miss that appointment. Also, equally important, be back here on February the 26th, 9 o'clock in the morning for sentencing. If you don't come back on the 26th, you're not here at 9 o'clock, that'll be a factor I consider with respect to what's the right consequence in this matter, and it won't weigh in your favor. Understand? Okay, we'll see you on the 26th.
All rise.
And as far as conspiracy, again, the evidence showed that Rosie Greer certainly has less culpability, less of a role, if you will, directing the employees to do what was alleged. Also the fact that she was an assistant manager. She was the lowest management position of the three defendants. And finally, that she was relatively new to the job, maybe 6 months in the job when this thing occurred. So it's understandable.
So to those outsiders that may not have the full chapter and verse that maybe think, well, if there's a policy as they protected and they weren't carrying it out, but shouldn't the people who allowed this to happen be in the document?
Well, we'd certainly love to hear from the defendants as far as who directed them to do that. We've been trying to get information from the beginning of this case, if anyone did. But, quite frankly, we don't know it yet. We haven't had an opportunity to listen to their side of things.
So we'll be approaching them again.
Perhaps, certainly at sentencing, I'm sure they'll be able to make some statements.
What did you say, last comment you made? You said they'll be able to make statements.
Certainly, we can listen to their statements. To this point, we haven't obviously had an opportunity to talk to the defendants. And certainly we'll be listening if they have any more information as to, what happened here. If anyone else was involved, we've always been ready to hear that.
Would that weigh into the sentence you might suggest?
If the court allows us to recommend a sentence, certainly any type of anything we get to the truth of this matter, that is what happened as well as who else was involved. Certainly that would be consideration for a sentencing recommendation.
So you don't think you're at the truth?
No, I don't know, Bill, right now. Certainly at this stage of the game, as far as they're involved, the truth has been found here by the jury's verdict. There's only less than 2 to 3 defendants here. As I indicated before, I certainly understand Ms. Greer had played a lesser role in this whole affair. She was there, she had a lower management position too, and also she had been just recently employed in that management position. So the jury's verdict is understandable, given the fact that we found the 2 defendants guilty. And I might add guilty of the most serious offenses here, which requires, it's not only a felony, but also requires automatic termination.
The jury rejected 17 of the 21 charges you wrote. Is there any you brought? Forgive me. The jury rejected 17 of the 21 charges. Is that at all a repudiation of what you wrote?
No, I don't think so, because really all the charges are simply different laws that cover the same conduct. The same conduct, no matter what charge you wrote, there's really an issue here. And the jury again found that 2 of the defendants guilty of the most serious offenses, felonies of 4th degree, as well as a misdemeanor offense. So I think we're satisfied with the verdict, and we accept the verdict of the jury.
If they do not offer you something from the defendants, will you recommend jail time?
Well, again, all we want from the defendants is truth. It's the truth of what happened. And I don't know yet, because I haven't had an opportunity to read the pre-sentencing report and investigation. I've been focused on the guilt phase of this case, the culpability of the defendants involved here. I really haven't focused on sentencing, and I will certainly before February.
Does this type of verdict change the system in any way?
I think it does. I think what it does is make sure that our election officials are more accountable, more responsible. Hopefully this makes it more clear that transparency is very important in the process, in the election process, which is already mandated by the laws. Hopefully be put into place, not only here in Calumet County, but across the state.
From your point of view, does the argument of not knowing hold up at all, considering what we're talking about?
Well, I think they knew. I think it was pretty clear from the evidence. I think the evidence was overwhelming in this particular case. As I said before, it's tough for a jury anytime to convict anybody beyond a reasonable doubt. It's not something I'm sure that they enjoy doing, especially people where there's no one individual victim, as we usually have in criminal cases. But clearly, I think this is a verification of the evidence and verification of what happened here and the culpability of the people involved.
Can you get your name on camera if
Sure,
I'm
no,
going to
please, go ahead.
Kevin Baxter,
Yes.
prosecutor in County.
Absolutely, thank you.
Kevin, they just followed orders. They didn't create these procedures. These procedures have been in place for over 2 decades. Why are they guilty of a crime if others are not?
Well, Bill, we'd love to know who gave the orders. We have never been told that. We don't know that occurred. But certainly if they have any information to that effect, I've always been ready, willing to listen to that. And actually, we've been in search of the truth. We want to hear that.
If the orders came from the Bill Mason's office, would he also be held culpable? Would you go after him the same way that you went after these defendants? If the order was given through Mason's
First of all,
office?
Bill Mason is a member of the Board of Elections. So I don't think the evidence doesn't even substantiate or remotely substantiate even that question.
What about Reno Ordini?
Again, Reno Ordini testified here we put him on as a state's witness, and Reno Ordini, I think, testified clearly, and he was subject to cross-examination by all three very skilled defense attorneys, and the jury's verdict is what it is.
Got it.
Thanks for your time.
Do you think there will be any more indictments?